If you care about the health and survival of democratic institutions, then what unfolded today deserves your full attention. What happened in a federal courtroom in Manhattan was not a routine legal dispute, nor was it merely another headline in an already crowded news cycle. It was a direct test of whether the rule of law can still function when powerful individuals decide that it does not apply to them. This was a moment that exposed stress fractures in the justice system, fractures that are becoming increasingly familiar to anyone who follows modern politics, whether in the United States or here in the United Kingdom. Courts, after all, rely not only on legal authority, but on respect for process. When that respect collapses, the consequences extend far beyond a single case. At approximately 11:47 this morning, during active federal proceedings, something extraordinary occurred. Three of the highest-paid defense attorneys in the country stood up from the counsel table, gathered their documents, and attempted to leave the courtroom while a federal judge was still speaking. Let that settle for a moment. These were not activists, not protesters, but licensed officers of the court, individuals sworn to uphold the Constitution, attempting to abandon proceedings mid-trial because they disagreed with a ruling. Such behavior is almost unheard of in a federal courtroom. It is not advocacy. It is defiance. To understand how matters reached this point, the detail is crucial. The morning session began in a manner that observers described as unremarkable. The prosecution sought to admit a set of financial documents. The defense objected. This is standard procedure in complex white-collar cases. Nothing, on the surface, suggested the drama that would soon follow. However, context is everything. 48 hours before this hearing, an event occurred that only came to light because of a clerical mistake. A sealed filing meant to remain confidential was briefly uploaded to the federal court's electronic system, PACER. It remained visible for just 17 minutes before being removed. That short window was enough. Legal researchers captured the document. According to multiple sources familiar with its contents, the filing included newly submitted evidence by the prosecution. Encrypted communications between Donald Trump and his co-defendants during a period the defense had previously described as a complete blackout, claiming there had been no contact whatsoever. The documents allegedly detailed wire transfers amounting to $4.7 million, alongside what one source described as the most damaging financial paper trail ever assembled in a white-collar criminal case. This was not circumstantial material. It was direct transactional evidence. This morning, Judge Patricia Caldwell ruled that all 847 pages of this evidence were admissible. That decision marked the turning point. Lead defense attorney Robert Sterling rose from the counsel table. The court reporter captured every word. Sterling accused the court of abandoning impartiality and declared that the defense would not participate in what he called a predetermined show trial. His co-counsel echoed the accusation, alleging prosecutorial misconduct and refusing, in her words, to legitimize the process with their presence. Then, quite deliberately, they moved towards the exit. Now, it is important to understand who Judge Caldwell is. She is a Reagan appointee. She has served on the federal bench for 31 years. Within legal circles, she is known for her calm temperament and procedural fairness. Defense lawyers routinely regard her courtroom as one of the fairest environments they could hope for. Her response was measured but unequivocal. She warned the attorneys that if they took another step, she would hold them in criminal contempt and issue bench warrants for their immediate arrest. She then ordered United States Marshals to block every exit. Within seconds, 6 armed federal marshals positioned themselves at the courtroom doors. What followed was a 7-minute and 23-second standoff, an extraordinary scene by any standard, and one that has not occurred in a federal courthouse for more than 2 decades. It was a moment that crystallized the gravity of the situation, the justice system asserting its authority in real time against an open challenge from those tasked with operating within it. This was not theater created by the court. It was the inevitable consequence of an attempt to bend the system beyond its limits. The first act of today's courtroom drama was shocking. What followed made clear why the defense was so desperate to escape. Because once order was restored, Judge Caldwell placed something on the record that fundamentally altered the balance of the case. According to sources with direct knowledge of the proceedings, the judge disclosed that she had received a sealed ex parte submission from the Department of Justice earlier that morning. For viewers unfamiliar with legal procedure, this is not a routine matter. Ex parte submissions communications seen by only one side are exceptionally rare in federal court. They are typically reserved for cases involving national security, witness safety, or imminent threats to the integrity of proceedings. Judge Caldwell stated that, based on the contents of this submission, she was considering enhanced security measures and the possible sequestration of the jury. Every experienced criminal defense lawyer in the country understands what that signals. It suggests the existence of a cooperating witness, someone close, someone with direct knowledge, someone whose safety now requires extraordinary protection. Within hours, former federal prosecutor Andrew McCarthy publicly articulated what many in the legal community were already thinking. When defense teams hear about sealed ex parte submissions in cases of this magnitude, he explained, they know the walls are closing in. It means someone inside the defendant's circle has turned, and testimony is coming that the defense has not been able to anticipate or neutralize. Seen through that lens, the attempted walkout suddenly makes sense not as strategy, but as panic. What followed next was equally revealing. Less than 30 minutes after returning to their seats, Sterling's team filed an emergency motion for a mistrial, citing judicial bias and prosecutorial misconduct. Simultaneously, they moved to have Judge Caldwell recused from the case, arguing that her threat of arrest demonstrated personal animus toward the defense. The sequence matters, because by creating a public confrontation, the defense manufactured the very conditions needed to lodge multiple appeals. Regardless of how the trial ultimately concludes, these filings ensure that higher courts will be asked to review today's events. Legal analysts across the spectrum agree on one point. This was not simply courtroom advocacy. It was performance. And crucially, it appeared designed for an audience well beyond the walls of that courthouse. There are reasons to believe the episode was coordinated. Fox News camera crews were reportedly positioned outside the courthouse nearly an hour before the walkout attempt occurred. Conservative commentators were already tweeting about judicial overreach before details of the incident became public. That timing raises obvious questions. News does not normally move that fast without forewarning. The sealed ex parte submission itself offers further insight. According to Department of Justice sources, it relates to testimony scheduled for the following Tuesday from an individual identified only as Witness 14 in court filings. This witness is said to possess direct knowledge of the financial transactions at the center of the government's case and has reportedly been in protective custody since October. Protective custody is not extended lightly. It suggests credible safety concerns usually associated with organized crime or national security cases. The defense team's dramatic actions occurred precisely 96 hours before this testimony is due to begin. In legal terms, that timing is far from coincidental. Speculation about the identity of Witness 14 is now widespread. The prevailing theory points towards someone embedded in Trump's financial inner circle, a chief financial officer or senior controller with direct access to the transactions now under scrutiny. If that assessment is accurate, the potential damage to the defense is considerable. After the standoff concluded, Judge Caldwell delivered a statement that sent shockwaves through the legal community. She indicated that, given the defense's attempted abandonment of their client mid-trial, she was considering appointing shadow counsel to safeguard the defendant's Sixth Amendment rights. In practical terms, shadow counsel would mean court-appointed backup attorneys seated at the defense table, prepared to assume control instantly should the current team attempt to withdraw again. It is an extraordinary measure, rarely contemplated, and signals the court's concern that proceedings could be deliberately destabilized. The financial ramifications of today's events are already emerging. Sterling's law firm has reportedly billed more than $12 million in legal fees, according to federal filings. By Friday evening, Bloomberg reported that the firm had entered emergency discussions with its malpractice insurance provider. Insurers, it seems, are concerned that the attempted walkout could expose the firm to significant liability if it results in a mistrial or a successful appeal. Industry insiders suggest that insurance coverage itself could be at risk, potentially leaving partners personally exposed. That may explain reports of senior figures arriving at the firm's Manhattan offices late Friday night for what has been described as a crisis management session. Beyond the legal and financial consequences lies a more profound issue. If attorneys are permitted to abandon proceedings whenever rulings do not go their way, the integrity of the judicial system collapses. Judge Caldwell addressed this directly, warning that allowing such tactics would encourage every losing party to manufacture mistrials through calculated disruption. History supports her concern. In modern American legal history, only 3 comparable attempts by defense attorneys to abandon clients mid-trial have been recorded. In every instance, the defendants were convicted. In every instance, the attorneys involved faced severe professional consequences. The pattern is unambiguous. Attempts to turn courtrooms into stages rarely end well for those who attempt it.